Good morning, everyone. The Ministry of Justice is committed to ensuring that the judiciary is provided with the requisite tools needed and necessary to discharge its task fairly, justly, and expeditiously, as well as to abide by the requirement of the judicial oath to do right by all manner of people without fear, favor, affection, or ill will. To this end, thus, measures will be implemented to safeguard the integrity of the judiciary by ensuring that it serves the public as intended and to prevent adjudicators from succumbing to the temptation to abuse the enormous powers they wield. All members of the judiciary seek to maintain the highest standards of personal and professional conduct. This is as true here in Bermuda as it is with other jurisdictions. However, the absence of a judicial complaints authority to address complaints from members of the public with respect to the judicial conduct of rulings in court proceedings, separate and apart from their right of appeal from magistrates or judges' decisions, is a glaring omission in our domestic regime. The public is therefore denied the right to seek redress in such circumstances of abuse of power, and the system is denied a means of correcting and improving itself and to maintain a level of professionalism that is indispensable in effective adjudication. The establishment of a judicial complaints authority will correct this omission and bring Bermuda in line with other modern, reputable jurisdictions. The authority will be charged with addressing complaints and about professional and personal conduct of judges and other types of judicial office holder. Possible misconduct may include the use of insulting, sexist, or racist language in court, or inappropriate behavior outside the court, such as a judge using their judicial title for personal advantage or to obtain preferential treatment. In addition, the administrative section of the judiciary, which is charged with providing the services and support necessary to enable the judiciary to achieve its mission, will be enhanced by the creation of two new administrative bodies. The first is an independent Department of Court Administration, which will give the administrative arm of the judiciary greater autonomy in line with Commonwealth best practice and the principle of judicial independence. Such a department would have appropriate control over its own budget allocation and be able to establish a fit-for-purpose human resource policy for its staff, as courts in most modern developed democracies are able to do. For example, at present, administrative staff who have access to very highly sensitive information are apparently subject to the same vetting procedures as staff hired in less far sensitive areas of the public service. In addition to the Department of Court Administration, a Judicial Services Committee will also be formed to advise the Governor of judicial appointments, terms and conditions of service, and disciplinary matters as an informal alternative to a Constitutional Judicial Services Commission. At present, there exists an ad hoc committee are established to advise the Governor on judicial appointments from time to time, with the result that no sustained review of judicial services needs to take place. It is our aim to ensure the fair and proper administration of justice with new administrative enhancements and measures to strengthen the judicial framework and benefit members of the community at large. Thank you.
The throne speech, you'll need the governor's...
I'm sorry, pardon me?
You'll need the governor's permission to make this complaints authority come into being.
The Judicial Complaints Authority?
Because under the Constitution,
you're absolutely right. Under the Constitution, the governor is the one that is in charge of the appointment of the judiciary. However, I do not see any objections from him. This Judicial Complaints Authority is well established in many jurisdictions, the United Kingdom being one of them, and we'll be looking to perhaps model the United Kingdom's Judicial Complaints Authority.
Because a number of the people who are delighted to hear that your government's going to do this have already been in communication unsatisfactorily with the Government House issue of complaining to the governor because he's in charge and for having said it's none of my business.
Okay, I can't comment on that because obviously I don't know the circumstances.
People are waiting to hear.
Right.
Is government going to insist on this?
Yes, we are. And in fact, I have to give kudos to a number of people who actually spoke with me in January when I first returned back to the Attorney General's chambers, and this was something that we were thinking of, and they brought me some information and some solid information about what was happening here in Bermuda to support the government's position in establishing this Judicial Complaints Authority.
The Chief Justice himself was
Very keen, absolutely, absolutely, yes, indeed. It's probably unlikely, as with most legislative instruments as well as policies, they move forward as opposed to retroactively. One thing also that needs to be considered with respect to this is that the complaint will need to be filed generally within 12 months of the occurrence of the action after the appellate process has been concluded, after all the court proceedings have been concluded. And also I think it's important to note that this is not a avenue for a person to use as opposed to an appeal. This deals specifically with the alleged misconduct of the judiciary, not because of the matter was not found in their favor. So this is certainly different and separate and apart from that.
And you'd expect the authority to report back to the governor on their findings?
They would, because of course...
He would have to act on those findings?
Well, at this point, it hasn't been fine-tuned, but it would be... certainly the report would have to go to the governor because he is, of course, responsible for the judiciary. And he, in conjunction with the Chief Justice, will then make recommendations in terms of what would be the next steps. Oftentimes, if we look at the United Kingdom, for example, a lot of the cases involve basically almost like a sensitivity training, and that perhaps the judiciary are not necessarily as sensitive, or their conduct is not what we would expect of a member of the judiciary. Perhaps some of their wording may not be appropriate in terms of the use of various sexist comments, racial comments, and so forth. And it may be an issue of just being sensitively trained to certain issues.
The Ombudsman could not have done this.
Well, the Ombudsman has her own purview with respect to the legislation, which is separate and apart from what we're doing here. The Ombudsman's legislation deals specifically with administrative matters. This is separate and apart. This is a judicial matter which would come under His Excellency the Governor with respect to how this would be formed because of his overriding appointment provisions under the Constitution for the judiciary.
Would they have the power to remove a judicial figure for abuse?
Well, actually, that goes to the third item that I spoke to you about, which is the Department of Court Administration, the Judicial Service Committee, which will also be formed to advise the governor on judicial appointments. Right now, there is somewhat of an ad hoc committee that meets to discuss and interview persons for judicial appointments. This particular Judicial Services Committee will be formed not only to advise the governor of judicial appointments, but it would also be to advise the governor and discuss terms and conditions of service, disciplinary matters as well. So that particular administrative body, the Judicial Services Committee, would be seized with that, and they would have the power to deal with disciplinary matters of the judiciary and the magistrates. So they're all three tied together.
Do we have any idea how many complaints about judges actually made?
I could not. I think that would probably be a better question asked for the governor, because they'd obviously come to him. I have seen a few complaints that have been filtered to me as the Attorney General, and then I have to obviously in turn pass them on to Government House. However, I can say that the majority of the complaints that I have received really don't deal specifically with the misconduct of the judiciary, as opposed to them feeling aggrieved by the order that was made in their favor or against them.